day after the three criminal bills replacing the IPC, the CRPC and the Evidence Act were passed in the parliament, a massive political row has erupted. While the government says that the new bills are reformative and have shred the colonist imprint, the opposition says that they will turn India a police state under an authoritarian rule. Remember, the laws were passed in the two houses while 141 opposition MPs were suspended for indiscipline. Now, critics say that it's undemocratic to bulldoze the bills when there's little opposition left to debate it. But before that, let's first show you what Home Minister Amit Shah had said while introducing the new laws, claiming that they align with the spirit of the Constitution and will focus on justice rather than punishment. He's also emphasized that the bill will free people from the colonial mindset and its symbols. Listen in.
तीन प्रकार की न्याय प्रणाली है, कहीं मेट्रो जज होते हैं, कहीं नहीं होते, कहीं फर्स्ट क्लास मजिस्ट्रेट होते हैं, कहीं नहीं होते हैं। ये कानून पारित होने के बाद कश्मीर से कन्याकुमारी और द्वारिका से लेकर आसाम तक सभी देश में एक ही प्रकार की न्याय प्रणाली होगी। हमारा वादा था मान्यवर इस देश की जनता को, आतंकवाद के खिलाफ जीरो टॉलरेंस की नीति रखेंगे और आतंकवाद की व्याख्या ही नहीं थी। कुछ सांसदों ने, मैं बाद में जवाब देता हूं, कहा है कि यूएपीए में है, मगर जहां उनके प्रभाव वाली सरकारें थी वहां यूएपीए को लगाते नहीं थे। आतंकवादी कृत्य कर सादे गुना की सजा में निकल जाते थे। अब हमने ये मूल कानून के अंदर ही आतंकवाद का जिक्र कर ऐसे लोगों को जेल के बाहर आने का रास्ता लगभग असंभव कर दिया।
Meanwhile, the opposition has called it a draconian bill and it was a threat to democracy, they say. Opposition has pointed out the bill endangers civil liberties and gives sweeping powers to the police and the state.
The bill rightly says, from the colonial laws to a police state, that's been the journey of these laws. Why do they want to pass these bills without any discussion with in the parliament?
The soul of these three laws is unconstitutional. On the touchstone of constitutionality, Article 14, 19 and 21, they will not stand the test of the courts. These laws are draconian, they are authoritarian. They will lay the foundation of a police state in India.
जो बहुत महत्वपूर्ण बिल थे, जिन्होंने पूरे सिस्टम को बदलने की कोशिश की है, लोगों के, नागरिकों के मौलिक अधिकारों को बहुत आसानी से छीनने का प्रयास किया है। सीआरपीसी, आईपीसी और इंडियन एविडेंस एक्ट में संशोधन करके और आईटी एक्ट पास करके कि आपका फोन है, कोई है, किसी को भी गवर्नमेंट किसी के भी फोन को कभी भी टेप कर सकती है। कोई अब बाधा सरकार के पास नहीं है। आपकी कोई निजता का, जो सुप्रीम कोर्ट ने कहा था कि निजता का अधिकार मौलिक अधिकार है, उसको भी आसानी से छीनने का काम इन 3 दिन में हो कानून बना के।
You have eliminated opposition and you are getting bills passed. How does it help to strengthen our democracy, strengthen our constitutional morality? Let us see.
But sir, the provisions which have been brought in criminal laws, even Kapil Sibal has said that this government wants to...
I am not discussing the content in detail. I am saying the criminal laws, many experts have pointed out, they are giving more draconian powers to the police and those who are in power. Why it should happen? Because there was no discussion, there was no opposition.
And what are these objections? We're going to go one by one as far as these objections are. And first and foremost will be the sweeping police powers that the opposition is talking about. Now, there is section 187(3) of the Bharatiya Nagarik Suraksha Sanhita. And this says that the magistrate may authorize the detention of an accused person beyond the period of 15 days. Not exceeding 19 days in certain kinds of cases, and in fact specifies either in whole or in part at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days. So this is a very, very significant aspect that is being spoken about. And let's quickly open this up and take this. All right, there's another play that we want to quickly bring out to our viewers, and it also goes on to talk about the second aspect of it. The objection, of course, being that it enables the custodial torture and intimidation but there is little accountability that has been built in. It has gone on to say that the provisions are a threat to civil liberties and democracy as well. This is the second objection. The third objection is that custodial deaths have risen from 100 to 175 from 2021 to 2022. The objection 4 is that while 188 have died in custody, only 26 cops were convicted in the past 20 years. So close to 2,000 and only 20 convicted. In fact, marginalized as well as those with no recourse to law may be left vulnerable with such a provision. There's a sixth objection saying the Supreme Court in 1992 ordered that after 15 days, only judicial custody can be remanded, and that's the objection number 6. Number 7, as per the NCAT, 55 prisoners have committed suicide in 2020 due to torture as well. So the centre has also defended these particular laws. Let's listen to what the centre's defence has been. The centre, in fact, has gone on to say that under Section 121 of the Nyaya Sanhita, police can be prosecuted for torture. That is the defence coming in from the centre. So it's not like policemen are going to go unpunished. The more deaths in judicial custody in 2021-2022 than in police custody. So even in the jails, there have been similar figures of those who have died. The Supreme Court itself wanted to review its 1992 order on judicial custody, is what the centre said, adding that the decision to extend custody is left to the magistrate. They've also gone on to add the magistrate can give police custody only if the accused is brought in person. So these are the defences that have come in from the centre as far as the defence of these particular aspects are concerned.